Hi, boys and girls. Welcome to the Saturday morning children's program. I'm your host, Dummy McDuffie, and I'm here with Brandon Ketron, and we're going to give you tips on how to manipulate your parents. And the first tip is always keep them guessing. For example, your parents may have signed up for a really boring webinar today on PPP, which has nothing to do with your diaper patterns, and ERC. And actually, that will start soon, but thanks for joining our children's morning show. Goodbye. Hello, PPP and ERC enthusiasts. I'm Alan Gassman. I'm here with Brandon Ketron, who's taller than me, but you wouldn't know it. I'm 5'7", Brandon 6'1", just for full disclosure. And we are going to talk about the new PPP regulation that just came out and the employee retention credit. Brandon and I are lawyers with the law firm of Gassman, Crotty, DiNicolo, and Ketron. And we have made it a hobby and a passion to understand PPP and ERC, or at least I've made it my hobby and passion for Brandon to understand and explain PPP and ERC. And for those of you who are new to these webinars, we're not that good at it, but there doesn't seem to be anybody else doing them. We do welcome you to 10 a.m. on Saturday. Those of you in California, it's 7 a.m. Special thanks for joining us. Now, we have a for-pay webinar coming up Thursday, August 12th, 90 minutes for the Lineberg Information Services. You are welcome to pay for that, just so you know. And then we also have a Lineberg talk coming up on representing the distressed business. There's a free shorter version of this on YouTube that you can find if you search Gassman Distressed Business, which has nothing to do with our law firm itself. If you happen to live in Chattanooga, or if you like Chattanooga caviar, which is my favorite kind of caviar, Wednesday, September 20, we're going to be talking more about this in Chattanooga. And then if you want to reach your goals, come to Naples, Florida, October 8th. I'm going to be speaking to the law school there and alumni on how to be a successful professional. Hopefully I'll figure it out before then. Also, if you're a CPA, please support the Notre Dame Tax and Estate Planning Institute. Brandon will be there October 20. It will be virtual this year, and I will be there on Friday, October 22nd. So enough of this shameful self-promotion. Let's go straight to the subject today, which is PPP and ERC. So Brandon, all the attendees have what I'm showing here, the 30,000-foot view of the CARE Act support programs. Do you want to start here and just let everyone know what we're talking about today, and then we'll move into the details?
Yeah, so just to give everyone a little background information, if you're not familiar with these programs, you have the PPP program, which gave you a forgivable loan based upon 2.5 times your average monthly payroll. You had to spend it on necessary expenses that were forgivable. Their wages, rent, utilities, health insurance, retirement plan expenses, all those are countable towards your forgiveness. If you spend enough within a period of time, anywhere between 8 and 24 weeks, you can get the entire loan forgiven. There's no deadline for applying for forgiveness on PPP loans. Just if you don't apply within 10 months after the end of your covered period, you're going to have to start paying interest on those loans until they are forgiven. But there is no official deadline for applying for that forgiveness. There's also the employee retention credit, which is a tax credit that's given on wages up to $10,000 of wages in 2020. And you get a credit of 50% of those wages, so a max credit of $5,000 for each employee in 2020. You had to meet certain requirements. You had to have a 50% reduction of revenue, or you had to have your business suspended or subject to a shutdown order from a local government in order to qualify for their credit in 2020. A little bit different in 2021, only a 20% reduction in revenue required for the employee retention credit program, or you could still qualify if your business was shut down or suspended and you get a credit up to $7,000 per employee for 2021, and that's per quarter. So for all 4 quarters, you could get a $7,000 credit if you otherwise would qualify. There's coordination required between these programs. If you have wages, you cannot use the same wages for your loan forgiveness as you're using for the credit amount. So you have to coordinate between those 2 programs. The PPP loans, completely tax-free. You get to deduct the expenses. No issue there for taxes. A little bit different for the employee retention credit. You don't pay income tax on the receipt of the credit, but you do lose your wage deduction to the extent that you receive that credit. So if you get $50,000 of an employee retention credit, you have to reduce your wages that you're able to deduct by $50,000. So there's also a couple of other programs out there, just to briefly touch on them. There's a provider relief fund, which was sent to medical practices. Those are taxable payments. You have to spend those on healthcare related expenses or lost revenues. And if you receive the first round, the reporting's coming due September 1st, 2021. The portal is now open, so you have to go in and report how you use those expenses. There's different deadlines depending on when you receive the money. I think phase 2 deadline is December 31st, 2021. So just keep an eye on those deadlines, make sure you're following all the right reporting requirements if you received one of those payments. EIDL loans and grants, the grant was up to $1,000 per employee. You had to have a substantial economic injury here in order to receive a grant or a loan. That's a pretty high standard. It's not like the necessity standard for PPP. It's you had expenses that exceeded your revenue. Business is in really bad shape in order to qualify for the EIDL loan. These aren't forgivable. The grant doesn't have to be repaid, but the EIDL loan is a true loan, repaid with interest, 3.75%. 30-year amortization, so pretty favorable terms on these, but there are a lot of restrictions that apply and make sure that you did in fact qualify if you received the EIDL loan. So Alan, any comments on those programs and before we
No, great job. Do you want to just mention, or I can mention that there's a shuttered venue operator grant that is available for theaters and other venues that have had entertainment that had to shut down or reduce their activities, and it's a very, very generous grant program. And then there's the Restaurant Revitalization Fund, which I think if you represent or you are a restaurant, bar, or a brewery, then I'm sure you know all about this and that you're doing everything possible to get your monies. And Brandon, just to talk about restaurants quickly, tip money is really big at restaurants, and you can get the ERC credit on tips and then also another credit on tips if it is in the food industry. Is that correct?
Yeah, so there was guidance issued. The latest ERC guidance confirmed that you can get the ERC credit on tips. They're deemed to be wages under the code, so they qualify as qualified wages. And then there's also the Section 45B tip tax credit, where this program, I think the purpose of this was to encourage employers to report tips. And the idea behind it was if you pay Medicare and Social Security taxes, so the FICA taxes on those tipped wages, then you get a credit amount based upon the FICA taxes that you paid. They confirmed that you can receive both the ERC credit and that tip tax credit on the same wages. There's no coordination required between the two. So you can take advantage of both there and double dip for restaurants.
You can also tip your lawyers, but that doesn't really help you with this. But I just wanted to mention that you should tip your lawyers. Okay, we are getting a lot of questions, and let me just go ahead and answer 2 or 3 of them. Yes, after this presentation, you will get a copy of the PowerPoint slides. I'm sorry that we didn't send them, but we had about 2,000 registrants for this program, and we find that if we send 2,000 PowerPoint slides out, our computers stop for a while. We didn't want to risk that, but you will get them. Secondly, you should have as a download attachment on your control box there the ability to download the PDFs of the slides we just showed you, and we recommend that you print them on 11 by 17 paper, have them Scotch guarded or laminated, and then take them into the hot tub with your significant other and review this important information. We do have a lot of good questions here, but we will cover them at the very end to the extent that we don't cover them before then. But we do appreciate questions, and you will see you have our email address here in the bottom. And as I've said many times, please send me the easy questions, send Brandon the hard questions, and then no one will get hurt. So here on page 26, the three things that the SBA interim regulations that were published the day before my birthday, July 28th, have said. And the first thing is, if you have a loan or your total of the two loans for PPP are under $150,000, then you can use the online portal. And Brandon, why is that important?
Yeah, so this is a new thing that they've come up with, and let me just flip one slide here and just show you a little bit of kind of what it looks like. So this is now open. You have to have your lender opt into this program. So that's step one. You have to check and see if the lender has opted in. Some lenders are, some aren't. I would think that probably the large lenders are less likely to opt in than the smaller lenders, just because they have more resources to set up these portals and make it easier for borrowers to apply for forgiveness. But the nice thing about this, from what I understand, is that if your lender opts in, you go onto this portal, you put in your loan number, and it populates all of your loan information already. You just verify everything, put in what you had spent, and then submit your application for forgiveness. That directs it to the lender, who then approves and sends to the SBA. So it should be a more streamlined process, hopefully a more borrower-friendly way to apply for forgiveness, because there has been a lot of borrowers struggling with this. So we'll see how this works out, and hopefully it'll be a nice tool for borrowers here.
And Brandon, am I correct that if you did a PPP loan and then a second draw PPP loan, you have to have the total of the two loans being less than $150,000 in order to qualify?
I think it's each loan. I think if your PPP 1 is under 150, you can apply with this. If your PPP 2 is under 150, you can apply with this. I don't think you have to combine the two amounts together. Not 100% sure on that, but we can double check. But that's how I read it.
Okay. Then instead of if you're under $150,000, instead of proving that you had a revenue reduction, you can rely on your COVID revenue reduction score. So if you go to this portal and you fill out this questionnaire, and for example, you're a restaurant and you were shut down at least X days inside your restaurant, then the computer's going to say, okay, we don't need any further information. That's enough. So Brandon, what do we know about this COVID revenue reduction score? Do we know what the questionnaire is, or do we know what the formula is?
Don't know a whole lot yet. From what I understand, it was they've hired some experts to base this revenue reduction score given what industry you're in, where you're located, and the size of your business, and then it populates a score. If the score meets a certain threshold, then you qualify. So, if you're a restaurant in the city of New York, then, based upon that location and the shutdowns that occurred, I would think that revenue score would, qualify you. Now, if you were in a state that didn't have as many lockdowns and was not in a high transmission area, maybe the revenue score wouldn't cause you to meet that threshold. So it's dependent on borrower by borrower. You have to figure out what the score is. I'm sure we'll get more details in the next couple of days on this as more information comes out.
Okay, and then the third item is that if the SBA denies your application for forgiveness, you don't owe the money until you lose your appeal. So that's going to be really important for a lot of businesses that may have issues concerning their loans. Now they can keep the loan longer and put it in appeal. And I imagine these appeals may go years, given how many there probably are and how few SBA employees there are in the appellate division. So Brandon, anything to add on those three, or do we go straight to the most important one, I think, which is no more loan necessity questionnaire.
Yeah, so they have now repealed this loan necessity questionnaire. For this only applied if you had a loan of more than $2 million. You were required to fill out this form and submit it with your application. You no longer have to do that. And you're still going to be subject to audit for a loan over 2 million, and you're still going to have to prove the necessity of your loan. The SBA just decided that this questionnaire wasn't as useful as they thought it might be, and was a little more time consuming for borrowers, and it just wasn't necessary and was a waste of resources. So they've done away with this form, but I don't think it changes anything as far as you still have to prove your necessity of the loan for those over 2 million.
Right, right. So this is one where the early bird got sick from the worm. And as a matter of strategy, who knew this was coming? Would you have wanted to file this early and have a higher chance of audit, or file it late with everybody else on the earth the day it was due, and then you waited and procrastination was rewarded you? Maybe they got plenty of questionnaires that will keep the investigators' attention for years to come. If you have any question as to whether your loan was necessary, you really should see a lawyer, probably under the attorney-client privilege, because if your loan was not reasonably necessary to support the ongoing operations of the business, then you may have committed a felony by signing the application and receiving the money, and it would be safest to give the money back. So just because they're not requiring borrowers with loans over 2 million to fill out the necessity questionnaire doesn't mean that there's not a problem. And it's interesting, some of the insurance carriers in the United States will actually sell you necessity insurance. So then if the government comes back and says, give us our money back, the insurance company will pay the money. Now, the fact that they are not going to question necessity for borrowers who borrowed less than 2 million does not mean that the Department of Justice will not question that if there's a whistleblower action or a competitor squeals on their colleague competitors. So we do need to be careful out there. There's a lot of these that were applied for by businesses who were doing great and never really had a threat of problem. So we do have a Forbes article on this. If you search Forbes Gassman necessity, it comes up, and then you can listen to the Rolling Stones album and get continuing education credit for the time you spend doing that, and you could play it at slow motion. So now we're going to the employee retention credit. And here's one where if you applied early for certain people known as owners who have relatives and got your credit, then bless you. If you applied late, then now you have a major issue. So I'd like to cut to the chase here to the most important thing, and that's number 3, and that is, if I own a business, I'm the owner, I'm one of the workers, there's 2 other employees, none of my relatives are employees, I could apply for the credit, get the credit up to $7,000 a month during this year. I need it, I deserve it, but wait a minute, I have a wife or a husband or a child or a parent or a grandparent. I could be an orphan and only have one grandparent living, and I'm not eligible. So Brandon, what is the rationale behind this? Because I know all laws have rationale.
Yeah, so this is a strange one, and what they've done is applied the 267 attribution rules to deem any living relative essentially as the owner of the stock, and therefore that would establish one of these prohibited relationships. So when the ERC first came out, this FAQ was issued here about related individuals and whether their wages can qualify. So when you look at this list of disqualified relatives, nowhere on here do you see the owner or the owner's spouse. So you would think that the owner and the owner's spouse would be eligible. If they weren't, why wouldn't they just say that here? So then comes along IRS Issue Notice 2021 and said this parenthetical in Internal Revenue Code Section 51 causes the attribution rules to apply, and therefore you don't get the credit. So going to walk through a little bit of statutory construction here. For the non-advisors on the call, it might get a little detailed, but I think it's important to understand just how we get there and how the IRS is interpreting the language in the statute. So the original CARES Act says, for purposes of the employee retention credit, we're going to apply rules similar to sections 51I1. So you go to 51I1, this is the work opportunity credit language, and it says that if you have certain relationships that are defined under section 152 and these paragraphs A through G, then wages paid to those individuals do not count. If you are a corporation, if you own more than 50% of the stock and you have wages paid to one of these relationships, then those wages would not count. If you have a partnership or another entity, it's based upon your capital and profits interest, not necessarily your voting interest, but your profits interest in the business. And therefore, if you have one of these relationships and you're a 50% or more owner, then those wages don't count. Same thing for trusts and estates. It's all attributed up through to the beneficiary. So what are the relationships? Here they are: a child, brother, sister, stepbrothers, stepsisters, fathers, mothers, or ancestor of either, so grandpa, grandpa, great-grandparents, stepfather, stepmother, son or daughters of the taxpayer, nieces and nephews. So a long list here of relationships. So how exactly does 267 here apply to impact us? Well, 267 constructively considers individuals that are family members that are related as a brother or sister, a spouse, a parent or grandparent, or lineal descendants, so sons or grandsons. They're considered to own the stock of their family. And therefore, IRS Notice 2021 says that if you have a majority owner in a corporation and they have a related individual, those wages are not going to be considered qualified wages. We understood that. But if you're also the majority owner of the corporation and you have a brother, sister, ancestor, or lineal descendant, then the constructive attribution rules treat that ownership as owned by that descendant, and therefore now we have an established relationship. So dad owns 100% of S Corporation. Son is living on the beach, not related to the business at all, no involvement. The attribution rules treat son as the owner of the corporation, and son can't pay a wage to dad. So not eligible for the retention credit. So this is a direct example from the notice. Corporation B owned 100% by H. F, his son, is over here, no involvement in the business. Attribution rules consider F as the owner, and therefore the wage paid to H would be considered a wage paid to my dad, and therefore not eligible for the retention credit. And I saw a couple of questions here about when exactly does this apply. So the notice addressed a lot of guidance for the third and fourth quarters, but it also addressed several items that applied for 2020 and 2021, and this is one of those. So this also applies for 2020. So if you received a credit already on an owner wage that wasn't eligible, we'll touch base on what we think you should do, but technically that is not a eligible credit and was not considered to be a qualified wage. So let's look at another example. As we said, it only applies if you own a majority of the corporation. So here we have H that owns 49%. So at first glance, you think this wage is eligible, right? Because he's not a majority owner. Well, remember, we still have the attribution rules. So F and H ownership is going to be combined here. H is going to be deemed to own 51% of the company, along with his son his son F. So then the wages paid to H are not going to be eligible. You have unrelated party over here who owns 49%, no other relatives owned in the business. Even if that unrelated party has relatives, because he's not a majority owner, that wage is still going to be a qualified wage for the employee retention credit. So
Brandon, what about if the day before we file the application, H converts his stock to the only voting stock, he keeps 49%, and F sells his stock to the unrelated party? So now H is 49%. He controls the company. He may get a bigger salary, but he only owns 49%. go backwards in time and apply, or is it based upon ownership during the applicable quarter? Is it the whole quarter, half the quarter?
Yeah, it hasn't been addressed, but I think it would be, the relevant inquiry would be when was the wage paid and what was the ownership when the wage was paid. So if you change the ownership to get H under the 49% by selling F to someone else, then wages going forward could qualify as qualified wages, but you wouldn't be able to go backwards and count the wages as qualified wages.
We have hundreds of CPAs on this webinar. I'd be interested in if anyone could, and I'll send you a free book if you do. Can anyone here tell me a rule that has been so dumb, that has nothing to do with anything, to say, well, if you don't have any relatives, you can get it, but if you have any relative anywhere, you can't get it, and that's just not relative.
Yeah, so here, as Alan said, you know, this example 3 directly from the notice that says we have a corporation owned 100% by Jay. He's married, but they have no family members. So no mom or dad, no grandparents, no son or daughter, no brothers or sisters. And therefore, since there's no family members to attribute the ownership to, those wages can count. So what they're doing here is really punishing families, which is unfortunate. Doesn't seem to be a good policy. So very, very confusing situation, and really strange way to attribute the attribution rules.
Okay, and by the way, we're going to go over the 30 minutes, and of course, my shameless self-promotion was 4 or 5 minutes, so we're going to go over that. But so, Brandon, here's the next question, and you can go to whatever slide it's on. Obviously, first of all, how long can I wait to see if the SBA is going to fix this before I file for this credit going forward? Is there any deadline going forward? Is it 3 years, so I should just wait?
Yeah, so there's a 3-year statute of limitations to apply for the credit. So you can wait as long as 3 years from when the return would be due to file the 941X to amend the originally filed return and claim this credit. So we have a good amount of time if we haven't already applied. So you can wait and see what happens.
Okay, what about if I file for the credit and I ask for the credit? I could explain that I have relatives, but none of them like me or speak to me, and that I disagree with the view of the SBA on this. I mean, the view of the IRS. I'm sorry, the IRS needs to fix this, not the SBA. Am I penalty proof if I prominently disclose it, or does prominent disclosure only apply to Form 1040s, or stay tuned while we figure this out?
Yeah, so I think you know if you are filing a return that's adverse to a Treasury regulation, which is essentially well, it's not a Treasury regulation yet, but it is a published notice. You would have to file a disclosure, you know, saying you're taking position adverse to that, and I think that would likely be subject to penalties and interest if, you know, the IRS, if ultimately you're incorrect. I don't think you could get away with anything related to reasonable cause now. Hindsight, you know, back when we filed, you know, already filed returns, I think certainly we have a reasonable cause excuse to avoid penalties on failure to deposit or failure to file 941s, or, you know, by receiving this credit. So if you receive the credit and return it, I don't think there would be any penalties or that would apply, because you can have a reasonable cause statement, reliance on a tax advisor, reliance on an FAQ that didn't list an owner or an owner's spouse on the list of prohibited relationships that was published by the IRS. If they wanted to apply the rules this way, why wouldn't they just list the owner and the owner's spouse there in that originally issued FAQ? So certainly a lot of excuses and justification for a reasonable cause statement to avoid penalties.
Okay, so let me just make it clear for everybody. If you've already done this for a past quarter and you didn't know about this rule, then we think you're okay. We think you wait. If they audit it and penalize you, we think they'll waive the penalty because there was no reasonable cause. There was no reasonable notification to taxpayers. It was confusing. And there were authors out there, including us, who thought it was okay, that I think you could reasonably rely upon me. My wife will not rely upon me, but a lot of people will. Now, going forward, not so much. You would do this at your own risk, because it's Now it's against an IRS published ruling. But here's the other question, and the answer is a happy one. Do I have any obligation whatsoever to amend the prior returns, which I filed before this nonsensical regulation came out?
Yeah, and the answer to that is no. You have no obligation. There's a few regulations out here. This 1.451 is one where you can see the language here. It says if you ascertain that an item should have been included in gross income, you should, within the period of limitations, file an amended return. Doesn't say you're required to amend the return. There's a U.S. Supreme Court case where a judge said that amended returns are a creature of administrative origin and grace, and there's no statutory requirement to file an amended return. Now, as tax advisors and as practitioners, we have an obligation to advise you that you should file an amended return, but that's your decision whether or not you decide to do that. We have to advise you of the consequences. We have to let you know that you made an error, but nothing requires you to correct that error. It's the IRS's obligation to discover the error upon audit and then assess penalties and interest if applicable, but you have no obligation to alert them of the error.
Okay, so let me rephrase what I said a few minutes ago, tape recorded in front of hundreds of people. I advise everyone who is listening to this to amend your 941 to comply with this regulation, but there is no legal requirement that you do so. So I have complied with Circular 230. Okay. Does that pretty much cover that part of the ERC changes?
Yeah, and we have an article on that. We're going to be writing more on this, and we'll just see what happens. I think there's going to be a lot of unhappy taxpayers here. So write your congressman. Hopefully they can pass a fix for this. I don't think this is what they intended. So we'll just have to see what happens here.
Okay, so Brandon, we do have a lot of questions about tips. So you want to just go over the first couple of items there?
Yeah, so the notice 2021-49, most recent notice, 100% clarified that cash tips paid to employees are considered as wages and therefore can be treated as qualified wages as long as all the other, the business is eligible. You're not claiming more than $10,000 per employee per quarter for 2021. So tips are okay, those can be counted. The tip tax credit, you can double dip on this. There's no need to allocate wages between the two, so that you can take the ERC credit along with the tip tax credit on both of the same wages. Only spot you can do that. Everywhere else, you have to allocate wages across all these programs. We talked about number 3 in pretty good detail. Number 4, large and small employers. If you have more than 500 employees in 2021, you only get this credit if the employee stays home and doesn't provide any services to the business. So when you're making that determination, it's full-time employees working over 30 hours a week. It's not full-time equivalents like it is for PPP loans in SBA world. This is a true full-time employee, strict head count here, not equivalents. And the notice confirmed that applied as well. And then the other item here, a lot of us didn't apply in 2020 because you weren't allowed if you got a PPP loan. And then at the end of the year, they said, oh, we messed up. You can get ERC and PPP. So we filed amended returns to claim the credit in 2020. Might have filed our 2020 return before we received that credit and didn't reduce our wages. So the question was, do I have to file an amended return in 2020 to correct my wage deduction? And the notice said the answer to that is yes. We can adjust in a later year. We have to adjust our deduction in the year that the credit was, that in the year that the wages were paid or incurred, that gave rise to the credit. So if it was a 2020 wage, you got to adjust the 2020 return and reduce that deduction for the wages.
Okay. Very good. So Brandon, anything else we should cover, or is that pretty much the high points? I know you and I have been working feverishly on updating our book, and I hope we're going to be done today or tonight, you think?
Yeah, I should have it done tonight. Should be published by Monday, the new update.
So there's two ways to buy the book, in case you care. One is you get the hard copy on Amazon, or they may have an electronic copy on Amazon. If you do buy it on Amazon, then let us know. Just send us proof, and we'll send you your choice of any other book that you will see in our Amazon library, and a redlined version as well. We'll send you a redlined version. Now, the alternate is if you buy it from the Lineberg people, it's less expensive, and they will, once you buy it from Lineberg, you can always update it. So if you already bought the book from Lineberg, you can go there, and certainly by Tuesday, it will be updated. You can get the updated version from Lineberg, because Brandon has a lot of diapers to pay for. So we've given you the actual PPP regulation. We've given you our Forbes articles. I want to thank you, everybody, for participating in this webinar. And now, Brandon, do you want to answer some questions for those people who have not fallen asleep yet and have not left this complicated and hard to understand webinar?
Yeah, one I'm seeing here that we get a lot is why have I not received my credit? I submitted this question as I submitted my amended return back in January, still haven't received my credit, and that's been pretty common. Originally filed 941s for the quarter, those have been processed quicker than amended returns, but it is taking a significantly long time for these to be processed. So stay patient. I don't think you've lost out on anything. It's just the IRS is slow processing this. Another question about 50-50 owner employees that are unrelated. Are those wages eligible? And I think the answer is, let me just pull up the language really quick to make sure I'm not reading this wrong. But I want to say that those are not, because it's determined, well, you have to actually have more than 50% ownership. So true 50-50 partners, unrelated, you would have to have more than 50% ownership, but that might be okay. There are attribution rules that attribute ownership to the other partner, so you might get stuck there, but we'll check on that and see on 50-50 owners. But that might be allowed. Is there an ERC for the third and fourth quarters of 2021? As of right now, yes. It applies all the way through the end of the year, $7,000 per employee per quarter. There is a proposal in the infrastructure bill to eliminate it for the fourth quarter. That hasn't been passed. It hasn't gone very far. So we'll have to wait and see what happens, but at least for the third quarter, you'll have it now. Let's see, any others?
So James said, as much as I love the book, no, I've never seen a law this dumb. And then Janet says Section 99 regarding health insurance was pretty dumb law and was rescinded. Well, that's great, Janet. I'm going to send you the book, and I'm not going to send you an outdated book. I'm going to send you this book when it's done, because that's a really good answer. And then Andy says ERISA stands for every ridiculous idea since Adam. Okay. And then Deborah says most small businesses are family owned and operated, so this is a shame. Yeah, I agree with that. Pamela, what do you suggest for those who have already applied for the credit? Well, again, I suggest that they amend their returns, but they have no legal obligation to do so. Hunter says, can I file a 7200 after the 941X is filed for an advancement of the ERTC? Brandon, how does that work now? Can they get an advance still?
Yes, you can file the 7200 anytime before the 941 is due. We have seen that those advances are also slow getting processed as well, and people have actually had more success waiting until the 941 is due and filing the 941 to get the credit that way. But there is still the 7200 advance out there that you can apply for. And then another question here is about coordination between the ERC and PPP. They got a credit in, or they got their PPP loan on February 2nd. The question is, can I use January's wages for the employee retention credit? Yes, because that's outside of your covered period. But remember, it's not a true, I can only count wages outside of my covered period. It's just I can't count the same wages twice. So you can overlap. If you had $20,000 of wages paid in the first quarter, that was all in your PPP covered period, you could send 10,000 of those wages to ERC and then the other 10,000 towards PPP, as long as you don't double count in any way. It's not the strict, if I'm in my covered period, I can't take a credit at all. That's not the case. It's just you can't double count the wages.
Yasmin had a good question. Would we send her a sample letter to the congressman? And I think we will do that, or if anyone on this call wants to send us a sample letter to your congressman, your senator, and President Biden, we'll be glad to share that with everybody who's on the webinar.
Yeah. Another good question.
Brandon and I have another webinar at 11 on estate tax planning. You're welcome to join us if you like. But we got to wrap this up. Brandon, you want to pick your favorite 3 remaining questions, and then we can address the others in future webinars.
Yeah, so here, what about a sole proprietor that only employs their spouse? Can the ERC on the spouse's wages? So unfortunately not, because the son, if they have a family member, so let's say they have a son, the son's going to be deemed to be the owner, and then the son can't pay wages to his mom to qualify. So that unfortunately doesn't work. The other one here is about if I opened a new business in Q3 of 2021, does the recovery startup business credit apply? And yes, if you're a small business with less than $1 million of receipts, you can qualify for the employee retention credit regardless of whether you meet any of the other tests. So you don't have to have a revenue reduction. You don't have to have a suspension of the business. If you start a new business, you qualify with below $1 million of annualized gross receipts. And that occurs if you started after February of 2020. Your credit's limited to $50,000 in total, and you still have the $7,000 per employee limitation, but that is a nice benefit for startup businesses.
Lewis has another question and an observation, which we appreciate. The question is it okay? You already had filed this under what you thought the rule was. Now you get the check. Is there anything wrong with negotiating the check? And the answer is no. You can negotiate the check. It was the state of mind of the taxpayer at the time they filed the return, or they could endorse the check to their lawyer or CPA, which it'll be very much appreciated. And then Lewis also said, stop referring to this as a regulation, darn it. It was an announcement, but it does have the same force and effect as a regulation, I believe, doesn't it, Brandon?
Well, not exactly, but you still can't do anything that's completely contrary to the notice. It's not binding in any way on the IRS. You can't use it as authority, but it is, you can't go against what it says in a published notice. It's still going to be an issue if you file something that goes against what the notice says.
Okay, Brandon, any final words here?
Yeah, this is a good question from Sergio here. If you wait and see on a previously submitted return, do you lose your reasonable cause excuse by not promptly amending once you realize it? And I think that you would have a reasonable period of time to digest the law, have notice of the law, figure out what you want to do. I mean, I think we have a couple of months to just wait and see what Congress might do, what the Treasury might do once they start hearing all this uproar. So I don't think there's any need to do anything immediately. Maybe if you waited 2 years, that might impact a reasonable cause statement, but I don't see a problem with waiting a few months.
And then Dan says the blue book, the ERC, did not have language warning us of this issue. Can that be used to argue that the announcement is invalid? And that's a good point. We'll look into that.
Yeah, and it's interesting. These are interpretive regs. The statute says rules similar to 51, so they don't have to be exactly like the way they applied the work opportunity credit language. And it seems like if this was what Congress intended, that they would have thought of this and said it, in in the statute, and then the Treasury should have said it in their initial FAQs that they published. So very strange.
Okay, and then I like what Karen says here. She says, I wouldn't do anything right off. Give it a couple of months. They keep changing their minds on the rules every couple months. So if your client can afford to go without the cash flow, then go ahead and wait. If they desperately need the cash flow, it's safest just to apply for the owners other than the employees other than the over 50% imputed owners, and then amend that later when they fix it. I hope they will fix it. So we continue to welcome your questions, comments, and suggestions. We'll go through some of these and answer them sometime soon, which in lawyer talk probably means sometime Monday. You do have our email addresses. We've gotten some emails from some of you. And we thank you very much for attending this webinar and sharing this information with others. Have a great day and a great weekend. And divorce your spouse if you have no other relatives.